Now this organization has banned. What has it banned? It has banned the use of potassium bromate and potassium iodate. Although the talks are that potassium bromate has been exclusively banned, it cannot be introduced in any bread item. But so far as potassium iodate is concerned, this issue has been referred to a scientific panel. And this scientific panel will decide whether or not potassium iodate as a whole should be banned to be added to the food products. So this is the news, and this news has expanded in the last couple of days as well. So there are three things to look into this. What is FSSAI? What is potassium bromate? And what is potassium iodate? Let's look at all these three issues one by one. Very important and can be a potential question in your prelims examination. Now first up, what is this Food Safety Standards Authority of India? It's important to note that it is a statutory body. There are different kinds of bodies. There are some bodies which are called constitutional bodies. What do we mean by constitutional bodies? Those bodies which are mentioned in the text of the Constitution itself. For example, Union Public Service Commission, Election Commission of India, Finance Commission. These bodies which are mentioned in the Constitution are called constitutional bodies. But there are some bodies which are not mentioned in the Constitution, but they are created by an act of Parliament or state legislatures. That means legislature enacts a law. Based on that law, a body is created. Those bodies become statutory bodies. There are also a third category of bodies, which we call extra-constitutional or non-statutory bodies. Those bodies which are neither mentioned in the Constitution, which are neither created by an act of Parliament. That means government issues a notification or a regulation, and that regulation creates these bodies. For example, Niti Aayog. For example, National Development Council. So one thing to note here is that FSSAI is a statutory body. This statutory body was established under Food Safety and Standards Act 2006, and this act came into effect from 5th of August 2011. Although these dates are not important, but just to ensure that this is a detail with it, that means 2006 an act was created which came into effect on 2011. So this is FSSAI. But what is the task? The task is that in India, who manufactures food, right? Any organization or any institution or any company which manufactures food or articles of food, what are the science-based standards that we can lay for them? Science-based standards basically talking about how the food will be manufactured, how the food will be stored, how the food will be distributed, how the food will be sold, and at the same time how the food from outside will be imported. These 5 are very important points, can be a potential question in your prelims examination, so don't be confused. FSSAI deals with all these important areas: manufacture, storage, distribution, sale, as well as import. And what is the objective? The objective is to ensure the availability of safe and wholesome food for human consumption. That means the food that is available for human consumption must be safe. This is the primary task of FSSAI. Because as we know, initially there were many central acts, such as Prevention of Food Adulteration Act. Way back in 1954, there used to be Fruit Products Order. I'm making you write these points because I'll tell you the reason a bit later. Third, Milk and Milk Products Order. So basically, initially what was happening, there was this scattering of scrutiny. There was the scattering of control. If there was a food item that was to be looked into under Prevention of Food Adulteration Act, if there were fruit products, separate institution will look into that. If there were milk or milk products, a separate institution would look after that. A separate act will deal with the monitoring of these milk and milk products. So policymakers thought, why should we have this so much scattering of information, so much scattering of networks? Why can't we integrate all these areas into one single body and give this body the task to regulate all these areas? That means one body should deal with food, another body should deal with fruit products, another body should deal with milk products. Let's remove this problem and let's create a single institution which can take care of the entire ambit of these food products. That is why FSSAI was created, and the objective was to remove multi-level, multi-departmental control into what? This multi-level, multi-departmental control should be removed into a single line of command. That means now only this FSSAI will deal with the entire administration of food products, manufacture, storage, distribution, sale, import, everything under one umbrella. And this FSSAI comes under Ministry of Health and Family Welfare. That means Ministry of Health and Family Welfare is the administrative ministry of FSSAI. What sort of questions can be asked? For example, which of the following statements are true regarding Food Standards, Food Safety and Standards Authority of India? Statement number 1. To promote general awareness about food safety and standards. So this is something that you can make out easily. If FSSAI deals with food safety, so its objective should be to also create awareness about safety and standards, right? Second, this is something that you might miss. To promote training programs. Training programs for whom? For those persons who are involved in food business as well. This is something that you cannot make out while the statement is given by UPSC, but this is an objective of FSSAI, to promote training programs also for those persons who are involved in food businesses. Third, to provide scientific advice as well as technical support. Scientific advice and technical support to whom? This is important. To both central government as well as state governments, both center as well as states. And what is this scientific advice, technical support talking about? How these central and state governments can frame policies, can frame those policies which have bearing on food safety and nutrition. So whenever a state government decides to create a policy framework for food safety and nutrition, the scientific advice and technical support will be provided by FSSAI. That means it's very important to point out that it acts as an advisor for both center as well as state governments. Fourth, very important point, laying down mechanisms and guidelines. For what? For certification. Because there are various bodies in India which are involved in certification of food. Whether the food is safe, whether the food meets the safety and standard requirements. For that we have various bodies in India. Who will decide what guidelines and what mechanisms are to follow while giving out these certificates? That guideline, those mechanisms are also decided upon by Food Safety and Standards Authority of India. These are four very important aspects, objectives of FSSAI, and can be a potential question in your examination. But what is unique about FSSAI? Because if you look at Food Adulteration Act of 1954, it primarily focused upon the final product, whether this final product is safe for human consumption or not. That was the only mandate of this Food Adulteration Act. But this FSSAI, what it talks about? It talks about food safety. That means it focuses on the entire food chain and not just on the final product, as was the case under Food Adulteration Act. But why are we discussing these things? We know what is FSSAI. We know the objective, we know the task, we know why is it unique. But why are we discussing? We're discussing because a premier organization in India, Center for Science and Environment, CSE. This Center for Science and Environment, in its study very recently, found out that 84% of the commonly available breads in India, packaged breads, they contain potassium bromate and they contain potassium iodate. So what is the big fuss about this? What is much ado about this? In most of the countries of the world, these two products, potassium bromate, potassium iodate, they have been banned. Why they have been banned? Because they are considered hazardous. Why are they considered hazardous? Because they are considered to be carcinogenic. That means cancer-causing substances. But it's important to point out that why should potassium bromate and potassium iodate be banned? Because they are hazardous, because they are considered to be carcinogenic. But where are these potassium bromate and potassium iodate used? This potassium bromate is used to strengthen the dough from which the bread is made. That means when you add potassium bromate, it makes the bread fluffy, it makes the bread soft, and it gives it a good finish. So because of these properties, because of these utilities, potassium bromate is used. But potassium bromate should be banned. Why? Because it is carcinogenic in nature. What about potassium iodate? Potassium iodate is basically a maturing agent. It improves the quality of the dough. That is why potassium iodate is also used. But if potassium bromate is carcinogenic, what about potassium iodate? Experts say that potassium iodate has huge quantities of iodine. And if any product has huge quantity of iodine, it is not desirable. Why is it not desirable? Because it will affect the functioning of thyroid as well. Thyroid gland functioning will be affected. That is why potassium bromate should be banned, because it is carcinogenic. Potassium iodate should be banned because it is affecting the thyroid functioning because of its huge quantity of iodine. But whether this potassium iodate is carcinogenic or not, the government has decided, let's leave it to a scientific committee. And this scientific committee should now recommend to us whether potassium iodate also should be banned or not. If these are oxidizing agents which are used in the bread, are there any alternatives? Can we use something else apart from potassium bromate and potassium iodate? We can use three things. And why I'm listing out these three things, I'll tell you after 2 minutes. There are three alternatives to potassium bromate and potassium iodate. One is you can use ammonium persulfate. You can use ammonium chloride, or you can use also amylases. But why should you remember all these three things? 2013 prelims examination. The question was asked on e-waste. Which of the following are the constituents of e-waste? The same year, the question was asked on that drinking water contains these important chemicals, including uranium. So such science-based questions, everyday common science questions, are usually asked by UPSC. That is why if potassium bromate is to be banned, potassium iodate is to be banned, which are these substances which can be used as an alternative to these two substances? So these are these three: ammonium persulfate, chloride, and amylases. Let's look at another important point. I'll take 3 more minutes because this is something very important. Everybody seems discussing it, and whenever some things are hotly debated in the media, be assured it's a potential question in your examination. Can this potassium bromate be harmless ever? Because we are saying that it is carcinogenic, cancer causing substance. But can this potassium bromate be harmless ever? Yes. Bread to which potassium bromate is added, that means the dough to which potassium bromate is added, then you make the bread. This bread, if it is baked at very high temperature, at a very high temperature, this bromate will turn to bromide. And this bromide is not carcinogenic. That means it is, for example, a statement is given to you: potassium bromate is always carcinogenic. Statement number 1. So you have to be assured that it is not always harmful. Why? Because when this potassium bromate is added to a bread, and this bread is baked at a very high temperature, this bromate transforms into bromide, and this potassium bromide is not carcinogenic. But experts, however, say we do not have any means to indicate at what temperature bread is being baked and how much potassium bromate is being added. So it's best to either not use these substances or use other alternatives. What are these alternatives? We have discussed that. 2 more things, which is what we call 2-day rule, which is also called test for bread. If you leave bread out for 2 days and there is no fungus on it, it is obvious that it has overdose of preservatives, because fresh bread will keep for only 2 days at most. If a bread is there, fresh, without fungus, even after 2 days, consider that it is not safe to eat because it has overdose of preservatives. Which of the following statements are true? Another backward linkages which we can link with this issue of food safety. International Agency for Research on Cancer is a World Health Organization body. Statement number 1. Statement number 2, and this might come shocking, particularly to the girls. Aloe vera internationally is regarded as carcinogenic. Is International Agency for Research on Cancer a World Health Organization body? Yes. Because this agency for research on cancer has made it explicitly clear that potassium bromate as well as coffee are carcinogenic in nature. High doses of coffee, and the coffee which is very hot, that can also be carcinogenic. And it has also termed that aloe vera, which is used in India very, very frequently, this aloe vera internationally is regarded as carcinogenic. So this completes our first discussion on this very important food safety issue. And I think if you have understood whatever we have discussed, I don't think you need to go through and read any other source. Let's look at issue number 2. Which of the following are priority programs of the government? This, you be assured, high possibility that this question will be asked, because there are 4 priority programs of the government, and all you have to do, you have to point out which are these 4 priority programs of the government. Pradhan Mantri Jan Dhan Yojana, Swachh Bharat Mission Gramin, Swachh Vidyalaya, Soil Health Card Scheme, Deen Dayal Upadhyay Gram Jyoti Yojana for rural electrification, Atal Pension Yojana, Make in India. Which of these are 4 priority programs of the government of India? And some of you may be surprised, because it is not Make in India, it is not Deen Dayal Upadhyay Gram Jyoti Yojana, it is not Atal Pension Yojana. The first 4 are priority programs of the government of India. This can be a very, very important potential question in your examination. Let's move on to something else. There was demand from army veterans and general public since many, many years, most vociferously since the Kargil War of 1999, that we should have a National War Museum and a National War Memorial. Now the Union Cabinet has given its go-ahead. Yes, we'll have a National War Museum, we'll also have a National War Memorial. But where? National War Museum at Princess Park Complex in Delhi, and National War Memorial at Sea Hexagon of India Gate. The construction of National War Memorial at India Gate was objected by the former Delhi Chief Minister Sheila Dikshit. but those were different concerns. We don't have to go into that. But primarily, since after many years and lots of campaigns after, the government has accepted the demand to construct National War Museum and National War Memorial. This can again be a potential question in your examination. Let's look at something else. Who is the Canadian Prime Minister? Very famous these days, particularly outside Canada mostly. Canadian Prime Minister Justin Trudeau. Can this question be asked in the examination? Clearly never. But why are we discussing Justin Trudeau? Justin Trudeau. He has apologized for Komagata Maru incident. And you know that this incident was a very important incident in our history and one of the principal factors for the defeat of Ghadar Party. So if Justin Trudeau, the Canadian Prime Minister, has apologized for Komagata Maru incident, then everything related to Ghadar Party becomes important in your examination. So you'll have to talk about Ghadar Party, understand it, what were their objectives. Understand about their mouthpiece, Ghadar Di Gunj, which used to be first published in Urdu, then in Gurmukhi. Also read about Lala Hardayal, because when Lala Hardayal escaped, it proved to be detrimental for the defeat of Ghadar Party. Three important events were responsible for the defeat of Ghadar Party, or for the objectives that Ghadar Party had set out. They failed in that. Why did they fail? Because Lala Hardayal escaped, Komagata Maru incident, and the First World War broke out. These three are important events which shaped the politics at that point in time, and this is something that can be a potential question in your examination. Any issues as of now? You can raise your hands. Do keep on sending your questions, and at the end of the lecture, we'll pick up all these questions one by one. Let's look at another issue. And before that, let me tell you something. Polity, economy, geography, modern history, every aspirant has studied these four principal subjects. But why is it that some people qualify prelims and some don't? It's primarily because you have to perform in areas other than these areas. Those what we call edge areas, such as art and culture, such as environment and ecology, such as general science. You see the dominance of these portions over the past few years, and you'll understand why I am speaking like this. Polity, economy, geography, history, everybody studies, and everybody is a master in these subjects. Everybody can answer these questions. But it is in these areas, such as environment, such as culture, such as science, where you have an edge over others, where you might have edge over others, and you'll have to sharpen your skills in that. That is why we are discussing something related to culture. Cheraman Jummah Masjid. But this is not something that I picked on my own because I like it. Prime Minister Modi went to Saudi, and the Saudi King Salman conferred on Prime Minister Modi Saudi Arabia's highest civilian award. And what did Modi give King Salman? Modi gave King Salman a gold-plated replica of Cheraman Jummah Masjid. Let's talk about few things about Cheraman Jummah Masjid, and then we will link it to something else. So let's get started. This Cheraman Jummah Masjid is supposed to be the first mosque in India. And this was built by somebody called Malik Dinar. It is believed that Cheraman Perumal, who was a Chera king, this Chera king went to Arabia, and in Arabia he met the Prophet. When he met the Prophet of Islam, he embraced Islam and converted into Islam. In 7th century, Malik Dinar is arriving in Thrissur in Kerala, and he is constructing this masjid, this mosque. But what is something unique about this mosque? In this Cheraman Juma Masjid, it is believed that there is an ancient oil lamp. And this ancient oil lamp always burns. And it is believed to be burning for more than 1,000 years now. That is something unique about this Cheraman Juma Masjid. But whenever Cheraman Juma Masjid is discussed, sometimes people confuse it with Adai Dinka Jopra. I think most of you might have read about this. If you have not read about this, then you have made a big mistake. Please go back and read about it. I'll just tell you a few details about this Adai Dinka Jopra. This Adai Dinka Jopra is in Ajmer city. This was a makeshift mosque. What do we mean by makeshift mosque? When Mahmud Ghori came to India, he ordered Kutubuddin Aibak that make a place for our worship. We don't know anything about this place. Make a place for our worship so that we can say our namaz. Ultimately, this Adai Dinka Jopra was constructed in 2.5 days. Adai means 2.5. This Adai Dinka Jopra was constructed on the ruins of a Sanskrit college. There was a Sanskrit college which was in ruins, and this Sanskrit college was converted into a masjid in 2.5 days. That is why it is called Adai Dinka Jopra. But why Jopra? There was no ceiling on this mosque. The material from which this mosque was constructed, that material was taken from the destroyed Hindu and Jain temples. So material from these Hindu and Jain temples were taken, and it resulted in the creation of Adai Dinka Jopra. Now, how do we know about this? This we are taught about by Alexander Cunningham. And you know who Alexander Cunningham is. I hope you know about him. Similarly, this is something about Adai Dinka Jopra. Similarly, people also view it with Quwwatul Islam Mosque. This Quwwatul Islam Mosque was constructed by Kutubuddin Aibak, and this Quwwatul Islam Mosque, which is widely regarded as the first mosque in India, but the first mosque in India is the Cheraman Juma Masjid. Quwwatul Islam Mosque is the first mosque constructed in Delhi. An interesting thing about this is that while this Quwwatul Islam Mosque was being constructed, in the adjacent way, Qutub Minar was also being constructed simultaneously. Quwwatul Islam Mosque is also important because it has a formal entrance. This entrance is what we call Alai Darwaza. Very important details from this year's examination point of view. We are talking about a gold-plated replica of Cheraman Juma Masjid, which was gifted by Prime Minister Modi to King Salman of Saudi Arabia. Now, there is confusion among lots of people that Cheraman Juma Masjid is not the oldest mosque in India, but it is Quwwatul Islam Mosque. It's not Quwwatul Islam Mosque, it is the first mosque which was constructed in Delhi. That is what Quwwatul Islam Mosque is all about. And this mosque has a formal entrance. This entrance is called Alai Darwaza, which is in red sandstone and white marble. Please remember these things, very important. Red sandstone and white marble. And this is important because this is considered to be one of the most important dome-shaped structures in the history of India. One of the most important dome-shaped structures in India. So this is about the issue that we discussed, the fifth issue that we discussed regarding Charaman Juma Masjid. Let's look at something else. Let's look at some of the facts, and I'll tell you why we are discussing them. Zoological Survey of India. This Zoological Survey of India was moved from Calcutta to Banaras. Why? This was moved during Second World War because there was apprehension that Japanese will bomb Calcutta, and ultimately most important specimens which are stored in Zoological Survey of India will be lost. So that is why it was shifted to Banaras. March 2016, a fire broke out in a science college in Calcutta and destroyed over 4,000 specimens. 4,000 zoological specimens. Not just this, April 2016. We are linking it with something very important, so keep in mind. March 2016, 4,000 specimens were destroyed when a fire broke out at a science college in Calcutta. April 2016, National Museum of Natural History. It went in flames. So something disastrous happened in India this year. But if something disastrous happened, despite all that, 2016 was an eventful year. Why eventful year? New discoveries of frogs, birds, and lizard species were discovered in India. Since environment and ecology, as I've said, has been a dominant theme in civil service prelims, let's look at some of these very important discoveries that took place in this year in India. Very eventful year. First one, fan-throated lizard. What is this fan-throated lizard? It's a small lizard with a large double chin. Why a large double chin? Humorously, perhaps, because they do not chew chewing gum. That's just a joke, don't take it seriously. So fan-throated lizard, a small lizard with a large double chin, but this is a principal feature of the males. Males have loose, stretchable skin which is hanging from their necks. And this fan-throated lizard, 5 new species of fan-throated lizards were discovered in India. I'm not saying that fan-throated lizard were never found in India, but fan-throated lizard threw up 5 different species which were never found in India. So that means 5 different species were discovered in India. According to IUCN status of those fan-throated lizards which were found in India, the status is least concern. But the most important thing about these fan-throated lizard is that their status talks about that it is found only in India. Something unique, and because of this uniqueness, it can be asked in the examination. So fan-throated lizard, it does not mean that we never had fan-throated lizards, but 5 new species of these fan-throated lizards were discovered. And if you look at the status of fan-throated lizards in India, it is found only in India, and IUCN status is least concern. Let's look at another one. Honameti bush frog. A new species was also discovered, Honameti bush frog. This is something very important because it is found in Western Ghats and it is native to Kerala, Tamil Nadu. So different varieties of Honameti bush frog were also discovered in India during this point in time, but there were previously many other varieties of Honameti bush frog which were in India, and if you look at the IUCN status, it is also least concern. So primarily sometimes the question can be asked, which of the following are endangered species in India? So you have to be absolutely sure that fan-throated lizard is not, Honameti bush frog is not. Third one, Microhyla laterite, or we sometimes call it as laterite narrow-mouthed frog. And this Microhyla laterite is also called as wasteland frog. There are some important details regarding this. That means the range of these wasteland frogs is about 146 square kilometers. And you know, if any species has a range of about 146 square kilometers, it merits an endangered tag. That means the IUCN, whenever it will conduct a new test, whenever it will conduct the new criteria, this Microhyla laterite, this wasteland frog, will be designated as endangered species because its range is about 146 kilometers and hence it meets the endangered criteria of IUCN's red list. That means if the question is asked today, is wasteland frog an endangered species? No. Why? Because it is not yet conferred with this title by IUCN's red list. Fourth and the last one, tree hole breeding frog. Now this is something that we have not discovered, but this is something that we have rediscovered. The last time this tree hole breeding frog was described in India was 150 years ago. That means this is not something that we have discovered, but this is something we have rediscovered this year. But there is a danger. The danger is that forests where these frogs have been discovered, they are fast facing threats. Trees are being cut, and without trees, frogs won't be able to reproduce. So this is the single most important threat to tree hole breeding frog. So these 4 species which we have discovered or rediscovered this year, they find a very important usage in your prelims examination. Fan-throated lizard, Honameti bush frog, wasteland frog, and tree hole breeding frog. We'll start with another important issue, but before beginning with that, just give me 2 minutes and I'll be back. Till the time you can ask your questions, type your questions, and we'll get back to you. Give me 2 minutes. So let's talk about another issue. Plastic or PET. If my voice is not clear, please raise your hands. Okay, so it's all clear. Plastic or PET, which is what we call polyethylene terephthalate. These bottles contaminate the medicine stored in them. Now these sort of issues might sound boring to you, but these issues are something which are asked in the examination. So this is where you can have edge over others. But this is something which is very important. Why is it important? And I'll tell you why. Plastic or PET bottles and the medicine which is stored in them is contaminated. How do we know about that? Tests were conducted. Who conducted this test? On the orders of the Health Ministry. And these tests found out that yes, the medicine contained in these bottles, they get contaminated. And these tests were later on endorsed. Endorsed by whom? DTAB, which becomes a very important organization or body for your examination point of view. Drugs Technical Advisory Board. And this Drugs Technical Advisory Board is the highest, topmost statutory authority for medicines. And this DTAB, Drugs Technical Advisory Board, it recommended that these plastic bottles or PET bottles and the medicine contained in them, if they are contaminating the medicines, how they are contaminating the medicines? That means heavy metals are leaching into the medicine. these tests were conducted. When the tests were conducted, it was found out that the medicines stored in these bottles are contaminated, and DTAB recommended, Drugs Technical Advisory Board, it recommended banning of bottles of medicines, especially for those medicines which we give for women and children. That means we should not be bottling medicines in plastics and PETs, especially those medicines which we give to women and children. Why? Because heavy metals are leaching into the liquid medicine. Which are these 4 heavy metals? Which get leached into these bottles or these medicines? Lead, antimony, chromium, and di-2-ethyl hexyl phthalate, or what is we called DEHP. These are the 4 heavy metals which leach into the medicine if these medicines are stored where? In plastic bottles or PET bottles. This is, I think, very important from your examination point of view. Let's look at something else. Enrica Lexi. February 2012, 2 Indian fishermen were shot dead. Who shot them dead? 2 Italian security guards. I'm not using the term Italian Marines as is commonly used by the newspapers. I'm using the term 2 Italian security guards, and I'll tell you why. These 2 Italian security guards were on board of Enrica Lexi. What is this Enrica Lexi? It's an oil tanker. They fired on another boat coming from the opposite side because they thought that these are pirates, and they killed 2 Indian fishermen. India arrested these 2 security guards and booked them for murder. But then subsequently the murder charges were dropped. Italy claimed that India has no jurisdiction to try these Marines as they were military personnel. That is why I'm using the term security guards. Italy said that India has no jurisdiction to try these Marines as they were military personnel on duty and therefore cannot be considered as terrorists. Why is Italy saying so? Because under international law, if this is the end of the land territory of India, the Indian territory will extend up to 12 nautical miles as well. That means the place where the land territory of India is extending, stretching till 12 nautical miles, which is close to 22 kilometers, till 12 nautical miles, this will also be the territory of India. But up to 24 nautical miles, this is what we call contiguous zone. And this contiguous zone is India's exclusive economic zone. What we are discussing? Enrica Lexi, an oil tanker, 2 Italian security guards are fighting, 2 Indian civilians are killed, matter is taken up by India, 2 Italian security guards are arrested. India is saying that we will try them for murder. Italy is saying you cannot try them for murder because that is not your jurisdiction. Why? They cited international law. What happens because of international law? India's territory extends up to 12 nautical miles as well. But up to 24 nautical miles is what we call contiguous zone, which is India's exclusive economic zone. This incident wherein the killings took place. This incident took place within 20.5 nautical miles. And what is the law stating? This is where it becomes interesting. If the incident took place within 12 nautical miles, if the incident took place within 12 nautical miles, then what will happen in this case? India will have the jurisdiction. If the killings of 2 civilians and fishermen took place within 12 nautical miles, then India will have the jurisdiction, will have the right to try these marines. If the incident took place away from 12 nautical miles, then United Nations Convention on the Laws of the Sea. This United Nations Convention on the Laws of the Sea states that if the incident took place in after 12 nautical miles, that means it is not Indian water, it is international water, or the incident took place in international waters. If the incident took place within India's waters, India will have the jurisdiction. If the incident took place in international waters, then either the flag country, that means on Enrica Lexi, on the top of Enrica Lexi, which flag was there? Either the countries whose flag was on top of Enrica Lexi, either that country will try these marines, or their home country, which is Italy, or its home country will try these marines. But we saw huge diplomatic standoff. India said no, it took place within Indian waters, so we will try them. Italy said no, it took place in international waters, so India does not have the jurisdiction. Ultimately, both these security guards were arrested. But few years down the line, one Italian security guard, he suffered a stroke, and on medical conditions, medical reasons, he was asked to go. He was given the permission to leave this country. The another marine, he was given bail to vote in the Italian elections. And the Italian High Commissioner made a solemn promise before the Supreme Court that I will be the surety, I will bring back this Italian marine after the election in Italy is over. And when the marine left India to Italy, from Italy, the Italian authorities are saying we will not send this marine back to India. Ultimately, huge diplomatic standoff, but that is not the point of concern here. Subsequently, this marine was sent back to India. But both Italy and India then decided, let's go for arbitration. Now, arbitration, you might have studied, when both the sides agree that their dispute shall be resolved by one body and whose decision shall be final. For this arbitration, they went to United Nations Permanent Court of Arbitration. So two statements become very important here. So you can be asked about United Nations Permanent Court of Arbitration. Where is it? Because if we see, most of these UN bodies are in Geneva. So your subconscious mind will tell you to tick on Geneva. But this United Nations Permanent Court of Arbitration is at Hague, Netherlands. So this United Nations Permanent Court of Arbitration, which is at Hague, India and Italy approached, and United Nations Permanent Court of Arbitration very recently gave an interim verdict. It said this Italian marine who is in India, he must approach the Supreme Court of India for the relaxation of bail norms. That means even today, And let's be absolutely clear on that. Even today, we do not know whether it is under India's jurisdiction to try these marines or it is under the jurisdiction of Italy to try these marines. This question is unsettled. It has not been settled yet. Only thing that has happened, and that is very important, only thing that has happened is that this Italian marine should approach the Supreme Court of India, and Supreme Court of India, if it wants, should relax the bail conditions of Italian marine and should let him go. But even if Supreme Court of India asks this Italian marine, you are free to leave this country, that means we are giving you bail and you can go to Italy. But even in Italy, this Italian marine will be under the jurisdiction of Supreme Court of India. Very important statement. This Italian marine went to the Supreme Court. Supreme Court granted him the bail. He left to Italy, and in Italy he will also come under the jurisdiction of not the Italian government but the Supreme Court of India. This is something which is ruled by United Nations Permanent Court of Arbitration. So if you might have read newspapers, the UN Permanent Court of Arbitration decision, a big blow to India. This is nothing like that. The question of jurisdiction has not yet been settled. We don't know whether India has the jurisdiction or Italy has the jurisdiction. The only thing that we know is that this Italian approached the Supreme Court of India and he was given the bail. This is all that I think you need to know in this Enrica Lexi case. Let's look at something else. These cigarettes and other tobacco products packaging and labeling amendment rules 2016. What happened because of this? We have had two important ministers, union health ministers in India, and I am talking about them with respect to this issue in hand, the menace of tobacco in India. Two ministers were upright and very determined to crush the tobacco menace in India, and these two were Dr. Ambubani Ramadas, who was health minister in the first UPA government, and the health minister in the first term of Prime Minister Modi. He has only one term, but health minister for the first time was appointed Dr. Harshvardhan. Then he was removed from his health ministry position and someone else was appointed. JP Nadda was appointed as the health ministry. I'm saying these two ministers were very efficient in controlling and very determined in controlling this tobacco menace. Dr. Harshvardhan made it clear that we will change the rules of the game. These cigarette packets, they should display warnings up to 85% of its area. But this was criticized by the tobacco lobby. Ultimately, if newspaper reports are to be believed, primarily because of this decision, Dr. Harshvardhan was shunted out from the health ministry. But that is not the point of concern here. The point of concern is, according to these rules, the size of pictorial warnings on these tobacco packs shall be 85% of their area, and that too on both the sides. So on both the sides, it will be depicted in pictorial warnings what are the harmful effects of tobacco smoke. But this is something which is very important from mains examination point of view as well, because our entire focus has been on smoking causes cancer, tobacco causes cancer. So all think that we want to scare the tobacco smoking individuals in the society is telling them that smoking causes cancer. And this is something that we'll have to do away with now. Why? Because it has not produced desired effects. As a smoker, I will tell you that the immediate cost of smoking is not cancer, but the immediate effect of smoking is neurobiological relief. So if I'm a smoker and these cigarette packets are telling me smoking causes cancer, I don't believe it. Why I don't believe it? Because I see the immediate effect is not cancer, but immediate effect is my neurobiological relief. I feel relaxed after I smoke a puff. That means because of these rules, what is happening? We don't see that more and more people are quitting smoking. If this strategy is not working, then we need to have an alternative strategy. What is that strategy? Number one, we should be telling people, apart from telling them that cigarette smoking causes cancer, although we should talk about them, but that should not be the principal objective of our campaign. The campaign should be how much money will a smoker save in a particular year. Cost saving should be the focus of our campaign. Not just this. If you are a smoker, when did you start smoking? When you were 14 or 15 or 16 or 17 or 18? It is in school and colleges that you, for the first time, start having a puff. It is there that we have to strike. And this ban on the sale of cigarettes to minors, it has to be effectively implemented. Effectively implemented. Because I don't see many people who have started smoking after the age of 25 or 26 or 30. Mostly the smokers that start smoking in their teenagers. That is where our campaign has to focus on. Ban the sale of cigarettes to minors and effectively implement it. And at the same time, ban loose cigarettes. If the packet of a cigarette costs 123 rupees or 130 rupees, I might not buy it, but still I'll continue smoking. Why? Because I can buy a stick. I can buy a stick for 14 rupees, 13 rupees, 15 rupees. So this is not an extra burden on my purse. But if I'm forced to buy one packet, maybe I will stop smoking over a period of time. That is where our campaign has to focus on. Ban the sale of cigarettes to minors, ban the sale of loose cigarettes, and implement plain packaging. Why? This is something that is working very good in Australia. If you go to Australia, there you can't purchase a branded cigarette. You can ask for a cigarette, but it is in loose, it is in plain packaging. It does not have multi-branding activity of these major tobacco companies. Because these youngsters today, why do they begin smoking? Fashion, show off. There's a guy who takes out a Marlboro packet and displays it, so it's a status symbol. The another individual takes out a Davidoff packet, it's a status symbol. The other takes out a classic packet, a regular, and that's a status symbol. That means you are flashing these very beautiful cigarette packets, and it is, enticing for these young individuals to lay a hand on one of these packets. So that excitement we have to kill, and that we can kill only by having plain packaging. Higher and higher taxes. Increase the specific duty on these cigarettes so that it becomes extremely difficult for these smokers to start smoking and continue smoking. This is the only important remedy that can help. Excessive higher taxes. And also, I think there is this argument from the government side that we get huge revenue from cigarettes, huge revenue from tobaccos and BDs. Yes, I agree. Huge revenue, not just from tobacco, but also from alcohol. Huge revenue. But there has to be one study. What is that study? Draw a balance sheet of what is the amount of revenue that you get by selling these tobacco products? What are the taxes that government is getting when people smoke? And what is the cost? Because there is no denying the fact that yes, cigarette smoking causes cancer, causes TB, causes other asthmatic abnormalities. So government has to bear the burden of treating these patients. So that incurs cost. That means who is bearing that cost? Government. Second, private individuals also. They also smoke and they do not get treatment in government hospitals, but at least in private hospitals. That means they are spending their money on treatment also. Treatment because of smoking, treatment because of the smoke. Ultimately, you will have to analyze what is the cost. Whether revenue that you get from cigarettes is more or the cost that you incur while treating these patients is more. If there is a mismatch, then I think we should have a complete ban on cigarettes once and for all. Because we are talking about demographic dividend. We are talking about these young individuals who tomorrow will be the drivers of Indian economy, drivers of Indian growth. We need them healthy and wealthy at the same time. That is why there has to be a complete ban on cigarette smoking. If you cannot have a complete ban on cigarette smoking, but at least look at the things that we discussed in the past. What is it? Ban on loose cigarettes, ban on cigarettes to minors, plain packaging, higher taxes, and make our campaign directed towards cost saving. What is the amount of money that we will be saving by quitting smoking? That's all that I think you need to know about these rules. Let's look at something else. Gram Vidyut Abhiyantas. There was a scheme of Government of India, Rajiv Gandhi Gramin Vidyutikaran Yojana, for the electrification of rural India, rural villages. That scheme was later merged with Deen Dayal Upadhyay Gram Jyoti Yojana. And this Deen Dayal Upadhyay Gram Jyoti Yojana is one of the most important schemes under the Government of India, which talks about electrification of those villages which have not yet been electrified. So based on the assurance which has been given by the states, Ministry of Power has set a target. The target is that we will electrify all these villages which have not been electrified yet in 730 days. That means in 2 years. How you can do that? For this purpose, these Gram Vidyut Abhiyantas, these will be appointed both at block level as well as at district level. What are we discussing? Rural electrification. What happens in rural electrification? Those villages which never saw the light of an electric bulb, those are to be electrified. But we still see after Rajiv Gandhi Gramin Vidyutikaran Yojana, after Deen Dayal Upadhyay Gram Jyoti Yojana, there are still some areas, some villages in India which have not yet been electrified. So Ministry of Power got assurance for this from the states that we will help you with that. And we will electrify all those villages in the next 2 years or 365 days. And for this, Gram Vidyut Abhiyantas will be appointed at both block level and district level. What will be the role of these Gram Vidyut Abhiyantas? What they will do? They will be the eyes and ears of rural electrification committees. That means they will conduct regular field visits, and they will also report progress, And these Gram Vidyut Abhiyantas will be responsible to ensure that electrification of these villages takes place on time. That means the time that we have set, 730 days, they will ensure that electrification of these villages takes time. That means it meets the guidelines. These are some of the important functions of Gram Vidyut Abhiyantas, which are to be appointed at every block and district level. These will be the eyes and ears of rural electrification committees. They will conduct regular field visits, report the progress, and ensure that electrification of these villages meets the timeline. Fine? And all these Gram Vidyut Yojanas or these Gram Vidyut Abhiyantas, they will report to District Vidyut Abhiyantas, because these Gram Vidyut Abhiyantas are there at the block level, at the village level. District Vidyut Abhiyantas will be at the district level, and these District Vidyut Abhiyantas shall have to coordinate with the district collector. Although this much detail is not required, but no knowledge is a waste. Everything is very important. This is something about Gram Vidyut Abhiyantas. Let's look at another issue. India Newborn Action Plan. This Indian Newborn Action Plan was launched in 2014, and it's no wonder it comes under Ministry of Health and Family Welfare. Fair. In 2012, there were 3 million neonatal deaths in the world. 3 million neonatal deaths in the world. Out of these 3 million, 7,79,000 took place in our own country, India. Thereby, India became the country where highest number of neonatal deaths took place in the world. But India has a deep problem. Majority of these deaths took place on the first day itself. Majority of these deaths took place in the first day itself, and not just this. There has been steep increase in these stillbirth deaths. That means first day death means a child is born today, but he does not survive the whole day, he dies or she dies. Another is an operation is conducted, or the mother is delivering the baby, ultimately the baby is born dead, stillbirth death. That is why we saw India Newborn Action Plan was launched. What is the objective? What is the aim of this plan? The aim is the attainment of single digit neonatal mortality rate, as well as single digit stillbirth rate. Two very important statements from examination point of view. What is the aim? The aim is to implement, the aim is to attain single digit neonatal mortality rate and single digit stillbirth rate. By when? By the year 2030. And this is the objective of India Newborn Action Plan. Let's look at another issue. Rights of Transgender Persons Bill 2015. This was a private member's bill. Now what's a private member's bill? A bill which is introduced by a minister becomes a government bill. A bill which is introduced in the parliament not by a minister but by any other member of the parliament, that becomes a private member's bill. This private member's bill was passed by Rajya Sabha. And this is supposed to be targeted at ensuring the right to life with dignity and right to personal liberty for transgender persons. Because if we look at 2009, a two-judge bench of the Delhi High Court led by Justice A.P. Shah, they decriminalized homosexuality. That was the landmark movement. But in 2013, Supreme Court said no, Section 377, which criminalizes homosexuality, is constitutional. But within a year, in 2014, the Supreme Court of India, the same Supreme Court of India which recriminalized homosexuality, the same Supreme Court of India is giving another gender type to the people of this country, recognizing transgender as the third gender. Not only males and females, transgender. Choose your gender. That means Supreme Court in that judgment said these transgenders and recognition of their identity is not just a social issue or a political issue, it's a human rights issue. So that judgment is still resonating in the parliament, and Rajya Sabha passed this Rights of Transgender Persons Bill 2015. What is the objective? The objective is, it talks about, these four statements are very important that I am making you write, very important from the examination point of view. Comprehensive national policy. There should be a comprehensive national policy. Why should transgenders be left out of the national policy? Because if we talk about the constitution, it begins with we the people. That means these transgenders are also part of this phrase, we the people. So there has to be a comprehensive national policy which will ensure the overall development of these transgender persons. Second, 2% reservation. And this is something which even Supreme Court talked about. Supreme Court talked about that these are minority communities in 2014. Supreme Court said these are minority communities and they must be provided with affirmative action policy. That is what this bill tries to do. 2% reservation. Where? In primary schools, in secondary schools, in higher educational institutions, and very importantly, in government jobs as well. Third, establishment of special, this is something very unique, special transgender rights court, which can deal with all these cases regarding the victimization, humiliation of transgenders. We have National Commission for Minorities, for Scheduled Castes, for Scheduled Tribes. We should also have national and state commissions for these transgender persons. And at the same time, fourth important statement, penalty for hate speech. Hate speech against transgender community should not be tolerated. Anyone who is found guilty of committing crime through his speech against transgender persons, he shall be imprisoned for up to 1 year and also shall pay fine. These are some of the highlights of this Rights of Transgender Persons Bill 2015. And this is a very important, a historic event. Because if this private bill is passed, it will become the 15th private member bill ever to be passed in the history of constitutional history in India. So this is another important issue that we are dealing with. There are people who are writing for break, although I did not want to touch this issue, but let's have a break for 10 minutes. Let's be back within 10 minutes. Welcome back to Byju's Current Affairs webinar roundup for April and May 2016. Is my voice clear? If it's not clear, please raise your hands. Everybody? Okay, so let's get started and let's talk about something very important which deals with draft geospatial, let me correct the spelling, geospatial bill. Do you want to create a map of India, or do you want to launch any service that depends on India's geospatial info? If you're trying to do that, there was some technical error from our end, sorry for that. What I was saying, do you want to create a map of India, or do you want to create any new service which uses these maps or which uses the geospatial information about India? If you want to do that, you'll have to apply for map license. What is this geographic data? Basically, natural or man-made physical features of India. That means primarily because of these satellites which capture the information about India, where there are hotels in India, national parks in India, where there is a restaurant, where there is a petrol pump, all these important man-made or physical features of India, this is what we call geospatial information or geographic data. Basically, any information which is described or communicated through surveys, through charts, through maps, or through coordinated systems. All these become part of geographic data or geospatial information about India. What is this draft bill basically trying to do? This draft bill basically tries to govern how any entity, whether it's a company, whether it's an organization, whether there are individuals, how these entities can use geographic data that makes up India. That is, there are entities which can be, for example, Google. Google uses Google Maps. These entities want to use geographic data that makes up India. If you want to use it, you will have to have a license by the government. Without a map license, you cannot publish or use any geographic data that comprises India. That means this draft bill basically tries to govern how any entity can use this geographic data. And if you publish it without the permission of the government of India, or if you wrongly depict the map of India, for example, there was a time when even Google used the Google map and it displayed that Jammu and Kashmir is not an integral part of India. The maps which depicted India was excluding Jammu and Kashmir. So you are wrongly depicting India's map. If you use India's geographic data without the permission of the government, If you're wrongly depicting India's geographic data, then what will happen to you? Fine from 10 lakhs till 100 crore, and punishment which can run up to 7 years for wrongly depicting India's map. Now there are two important points which this bill is implying. What are these important points? Although this is a draft bill, this is not the entire bill. This bill may suffer from serious amendments. The shape and form this bill might take will definitely change. But as of now, what is the information available with us? We can draw two inferences from this bill. One inference is India's geospatial data. This geospatial data is now owned by the government. It does not matter how you acquire this geospatial data of India. It does not matter. It is illegal to do so. It is illegal to acquire this information. It is illegal to depict this information, to publish this information without the permission of Security Vetting Authority. That means this bill tries to create a security vetting authority whose permission is required to publish these geospatial data and to disseminate the information contained in these geospatial data. Second, no person, and this is a very important statement, no person shall in any manner make use of, disseminate, publish, or distribute any geospatial information of India outside India as well without the permission of this Security Vetting Authority. That means tomorrow, if Google Maps is exiting India, it would still require a license to show India in its international version. This is something problematic because the problem is, how would India enforce such a clause? But that is something which we will discuss in detail. If this bill becomes an act, what are the implications of this bill in international arena? That we will discuss later when this bill becomes an act. But primarily, two implications that can be drawn from this draft geospatial bill. What are these? If these questions are asked, it means that all the geospatial data of India is now controlled by the government of India, and you have to seek the permission of government of India before you can make use of, utilize these geospatial information. And at the same time, no person shall make use of, disseminate, or distribute any of this geospatial data even outside India without the prior permission of the Special Vetting Authority, which is Security Vetting Authority. Let's look at another issue. This issue talks about criminal defamation. So I think you might have heard or you might have gone through the lectures of Subramaniam Swamy on YouTube, where he refers to one particular politician as a drug addict, as someone who is Buddhu, as someone who is a homosexual. Basically, you're defaming an individual. Ironically, both these individuals went to Supreme Court. Both Rahul Gandhi as well as Subramaniam Swamy, asking the Supreme Court that section 499 of Indian Penal Code. This section 499 of Indian Penal Code should not be used as a criminal law, but it should be used as a civil law. This code, this section 499 of Indian Penal Code, was inserted into Indian Penal Code in 1872. That means it is of British vintage. It is noteworthy to point out that when this criminal defamation law was added to Indian Penal Code, there was no codified criminal law in England. But even then, this code was put into place in British India. But the difference here is, what is a civil wrong? What is a criminal wrong? A civil wrong is a wrong against an individual. That means there are marital disputes between husband and the wife concerning two individuals. It's a civil case. There is a property dispute between the father and the son. It's a civil dispute because it involves two individuals. Criminal wrong is something which is a wrong against the state. But you will say, how is SC/ST atrocities a criminal law? How is rape against a woman a criminal law? Because you are raping one individual. You are violating the dignity of one individual. So how can these crimes be then criminal crimes? Because these are something that we talk about as impact crimes. For example, SC and ST atrocities. You're not committing atrocity against an individual, but against the community. Because the impact is against the entire community. That is why they are called impact crimes. And all these impact crimes are criminal crimes. Similarly, rape. Rape is an impact crime. It's a crime of patriarchy on women. Because it impacts the entire women community, it is a criminal crime. That is where we have to make a distinction between a civil wrong and a criminal wrong. But how is criminal defamation, or how is defamation a criminal wrong? Because you are violating the dignity of only one individual. So it should be a civil law. It should not be a criminal law. Arvind Kejriwal used some defamatory signs and language against Finance Minister Arun Jaitley. Arun Jaitley went to the court filing a criminal defamation suit against Arvind Kejriwal. Ironically, Arvind Kejriwal in the court was represented by noted lawyer Ram Jethmalani. And this is where it becomes very hilarious. The person who is complaining of defamation, in this case Arun Jaitley, he has to prove that he was a person of some character. That means if you are not a person of some character, if you are not a person of some good character, you cannot be defamed. Hilariously, Arun Jaitley's case, Arun Jaitley brought two friends to prove that he is a man of character. But Ram Jethmalani, who represented Arvind Kejriwal, he said that Arun Jaitley is not a man of character. Only a man of character could be defamed and no other. That means what we are talking about, it becomes very difficult to prosecute people for criminal defamation. And despite that, we have defamation in India as a criminal law. That is why many people today are writing that it is high time that we delete defamation from the criminal law statutes and make it only a civil offense. Because you are defaming an individual. How are you defaming the state? You're only defaming an individual. So it should not be a criminal crime. This is where mains examination comes into effect. And I'll tell you two important questions which can be a potential question in this year's mains examination. One, defamation as a criminal law. Is it time to rethink? The wording of this question will not be the same in UPSC, but the idea will remain the same. Wordings may change, but idea will remain the same. Is it time to delete defamation from the criminal law and make it a civil offense? Question number one. Or question number two. It is time to enact a post-constitutional penal code. Comment. Because the penal code of 1860 that we are still using, it has some archaic laws, such as this criminal defamation, such as section 15, such as the section on sedition 124 capital A, such as section 377 which criminalizes homosexuality. So it is high time that our penal law should meet the contemporary standards of the Indian citizens, and it's high time that we make a post-constitutional penal code. This is all that I think you need to know regarding criminal defamation. There is something else that happened recently in Delhi. 21 parliamentary secretaries belonging to Aam Aadmi Party, they are on the verge of disqualification. As per my limited knowledge, I think they won't be disqualified because they are not violating any principal position based on my limited understanding of Office of Profit. But there is a talk in the media that because of the pressure by the central government, maybe these 21 parliamentary secretaries shall be disqualified. Why disqualified? Because they may be holding offices of profit. This office of profit we have discussed in our first webinar in the month of August-September. But I'm going to ask you one question which can be a potential question in your mains examination. And that is, the office of profit loses its significance in an era of anti-defection law. Comment. How is this office of profit useless when we have a law such as anti-defection law in place? This is something that you will have to think about, and there is one beautiful article on Hindustan Times written by Vinod Sharma. He is the political editor with Hindustan Times. Go through his article and you will understand why office of profit has lost its significance in an era of anti-defection law. But this is something that will come in mains examination and not in the prelims. Let's look at another issue. National Capital Goods Policy 2016. So I will frame this issue from the perspective of a prelims based question, and then we will discuss it and you will come to know how some questions can be framed on this particular issue. Number one, which of the following statements are incorrect regarding National Capital Goods Policy 2016? Statement number A, it aims to increase exports from the current 27% to 40% of the production. Statement B, it aims at increasing the share of capital goods in total manufacturing activity from 12% till 20% by the year 2025 increasing the share of domestic production in India's capital goods demand from 60% to 80% by 2025. This capital goods policy is silent on goods and services tax, which is GST. Which of the following statements are incorrect? Number one, it aims to increase the exports from the current 27% to 40%. That means whatever we produce in India today, 27% of that produce we export. But this capital goods policy makes it clear that we need to increase these exports from current 27% till 40%. So this statement is correct. Second is, it aims at increasing the share of capital goods. These capital goods you discussed in your economic survey lecture, so I need not to explain them. But this national capital goods policy, it wants to increase the share of these capital goods where? In manufacturing activity. Because today in our manufacturing activity, the share of these capital goods is only 12%. And we want to increase this share to 20% by 2025. This also is a correct statement. Third, we are producing capital goods, right? The demand for whatever we produce in India in terms of capital goods, 60% of our production is meant for domestic consumption. And we want to increase this domestic consumption from 60% to 80% by 2025. Because you might have heard about the difference of opinion between Dr. Raghuram Rajan and Prime Minister Modi. Prime Minister Modi talked about his much hyped scheme, Make in India. That means we should make in India and then export it. Raghuram Rajan said the focus of Make in India should not be on manufacturing and then selling it and exporting it outside India alone. Because the world today will not recognize, will not accept a second China. Because China is a manufacturing giant. What Raghuram Rajan said, Make in India is good, very important, very much required. But Make in India for Make in India. That means Make in India, yes, manufacture in India, but for Indians. That means for domestic demand, for domestic consumption. Because if the world crashes, and we are seeing the drawbacks of the European Union exit, if the England will exit from European Union, the markets will have, there will be an impact on the markets. We are seeing that there are problems in Brazil. We are seeing that there are problems in Latin America. We have seen problems in Cyprus. We have seen problems in Greece. And how in this era of globalization, whatever problems take place anywhere else in the world, it has an impact in India. So if there is slowdown in the world economies, who will purchase our capital goods? Who will purchase our exported goods? That means if we make in India for exports, we will be on a very, very slippery wicket. So what we should rather do, we should make in India, but for India as well. That means for domestic demand, domestic consumption. This is the principal objective of this national capital goods policy. That means it wants to increase the share of domestic production in India's capital goods demand from 60% to 80% by 2025. But this fourth statement is wrong. Because national capital goods policy advocates the adoption of goods and services tax. So it's in favor of GST. It vehemently talks about that GST should be introduced in this country as quickly as possible. So this is about national capital goods policy. Let's discuss another issue. And this issue is something which I can consider the most important issue that we will be discussing in today's webinar. Most important issue. Not only because this is something which is frequently in the news, but also because of the fact that art and culture plays a very dominant theme in your prelims examination. Let's discuss this. There are things that we regard as important. Why important? Because we want to preserve these things for our future generation. They may be significant due to their present or possible economic value, but also because they create a certain emotion within us, or because they make us feel as though we belong to something. What is this something? A country, a tradition, a way of life. They might be objects that can be held, that can be touched, or they may be buildings that can be explored, or they may be songs that can be sung, and they may be stories that can be told. Whatever shape they take, these things form part of a heritage, and this heritage requires active effort on our part in order to safeguard it. This is what we call cultural heritage. But this cultural heritage does not end at monuments and collections of objects only. This is something that we have to talk about in terms of hardware and software. Basic childish definition of hardware. What is it? Some things that we can touch. Keyboard, mouse, screen. What is software? Something which we cannot touch. For example, this webinar software that we have installed, we cannot touch it. Although this is a very cheeky definition, but for the purpose of understanding, let me put this definition. Cultural heritage is not only hardware. These monuments which you can touch, these buildings which you can touch, not just this. There are some softwares also. This is what we call intangible cultural heritage, which cannot be touched. This intangible heritage should also be protected. What are some of the examples of this intangible cultural heritage? Oral traditions. For example, performing arts. For example, social practices. For example, rituals. For example, festivals. Very broadly, what I'm trying to say here, I'm trying to say that cultural heritage is something that we should be proud about, and every effort should be made to protect it, to improve it, to document it. And at the same time, this cultural heritage does not end at monuments, does not end at the collection of objects alone. But there are some cultural heritages which are intangible, which cannot be touched. For example, oral traditions, social practices, festivals, rituals. These are what we call intangible cultural heritages. And to protect these intangible cultural heritages, we have had convention for the safeguarding of intangible cultural heritage 2003. This is part of UNESCO, which is a primary, most important organization for the promotion and protection of culture throughout the world. And this UNESCO very broadly recognizes more than 300 intangible cultural traditions of the world. And in that list, there are 10 which are Indian in nature, 10 very important intangible cultural heritages of India which form part of this UNESCO group. All these 10 intangible cultural heritages we need to memorize, we need to understand, and this is something what we will be discussing now. Number one intangible cultural heritage, traditional brass and copper craft of utensil making among the Tatheras. Of Jandiala Guru, Punjab. You have to memorize, you have to keep note of all these 10 important intangible cultural heritages that are mentioned in the UNESCO list. Very important, can be definitely a question this year. What are these traditional brass and copper craft among the Tatheras of Jandiala Guru, Punjab? Eating and cooking in these metals is recommended in Ayurveda, and this is something that is promoted by these Tatheras of Punjab. How they make these traditional brass and copper utensils, this knowledge or information is an intangible cultural heritage mentioned in the UNESCO. Second, Kalbelia folk songs and dances of Rajasthan. This is also mentioned in intangible cultural heritage. Who are these Kalbelias? These are basically untouchable community. But this untouchable community, what they do? They perform these songs and dances. What are these songs and dances? In these songs and dances, they mimic the movements of snakes. And these songs and dances are usually performed on joyous occasions when they are filled with joy. So one is traditional brass and copper craft. Second is Kalbelia folk songs and dances of Rajasthan. Kalbelia is an untouchable community. What they do, they mimic the movements of snakes and ultimately perform these songs and dances on joyous occasions. Third, Chow dance. This dance is also called as battle dance. This Chow dance, very important statement, is a tribal martial dance. And this dance is performed to honor the god of destruction, Lord Shiva. That means Chow dance, which is also called a battle dance. It's a tribal martial dance which is to honor Lord Shiva. And this dance is particularly performed in the tribal areas of Odisha, Jharkhand, and West Bengal. These are very important statements. I have picked only those statements which are relevant for your examination, so that you don't have to go into details regarding these intangible cultural heritages. But please, please, and please make note of all these important points. Can be a potential question, definitely. So we have discussed three. Let's look at the fourth one. Buddhist chanting of Ladakh. What they do here, the recitation of sacred Buddhist texts in Ladakh. This is also something intangible cultural heritage which should be protected. But there is a special dress, something unique feature about this Buddhist chanting of Ladakh. There is a special dress which is used for chanting. And these lamas, who are these lamas? Basically monks. These lamas, they make hand gestures. And what they do through these hand gestures, they represent what Buddha has preached. Look at the beauty of this. Look at the beauty of the diversity that we have in India. You are performing dances, you are chanting, and through this chanting you have a specialized dress. And these lamas, they use these hand gestures. That means movement of hand is tilted in one way or the other. Why? To depict what Buddha has preached. The Dhammas of Buddha, non-violence of Buddha. This is the fourth in the list of those intangible cultural heritages which form part of UNESCO list. Fifth one, Sankirtana. What is this Sankirtana? This is a ritual singing, drumming, and dancing. And this is something which is performed in Manipur. And this is performed by the Vaishnava cult of Hindus. In Manipur, Sankirtana is part of intangible cultural heritage. This deals with the ritual of singing, drumming, and dancing, which is performed by the followers of Vaishnava Hindus. Similarly, the sixth one, which I don't think you need a further elaboration on, Ram Leela. Ram Leela is also part of intangible cultural heritage, the traditional performance of of the Ramayana. The seventh one, tradition of Vedic chanting. Vedas, which are four in number, you know about that. Rig Ved, Yajur Ved, Atharva Ved, Samved. Very important sources of knowledge which tell us about the ancient Indian society as well, which tell us about medicine, which tells us about songs, which tell us about the forests. There were, ironically, 1,000 ways of reciting these Vedas. And the ironic part is, only 13 out of these 1,000 ways have survived. And we need to protect even them. That is why it is intangible cultural heritage. Eighth one, this is something very beautiful. And this is something immaculate. Raman. Raman is a religious festival and ritual theatre which is confined to Garhwal or let me correct the spelling, which is confined to Garhwal Himalayas. But what is so special about Raman? What is so special about this religious festival and ritual, which is a theatre in Garhwal Himalayas? Something very beautiful. What is this something beautiful? This Raman is now confined to only 1,800 people. That means only 1,800 people belonging to 196 families, they perform this theatre of Raman. And 18 people play 18 characters. Look at the beauty. Wearing 18 masks to dance on 18 beats. To celebrate 18 Puranas. Isn't it immaculate? 1,800 people are now performing these Raman belonging to 196 families alone. 18 people play 18 characters wearing 18 masks to dance on 18 beats to celebrate 18 Puranas. This is the most unique and fascinating thing about Raman. This is the 8th on our list of intangible cultural heritage of India, which is mentioned in the UNESCO. Ninth one, Kutiyatham. This Kutiyatham is native to Kerala, and it is India's oldest theatre form. Kutiyatham, native to Kerala, is India's oldest theatre form. It is basically a Sanskrit theatre. So by looking at this word Kutiyatam, you might think that this is from Malayali, but it's a Sanskrit theatre. And there is something which is unique with Kutiyatam. The performers or actors who perform this Kutiyatam, they go through a very rigorous training in breathing control, in muscle shifts. That means they are taught how to control their breathing. They are taught how to use your muscle shifts, how to free your body, how to control your face. And this training lasts for 10 to 15 years. This is something which is very unique about Kutiyatham. That means that performers are trained for 10 to 15 years, then they become eligible to perform this beautiful Sanskrit theatre of Kutiyatham. Now the last one. Mudiyattu, which is a ritual theatre and dance drama. And again, it belongs to Kerala. Now the best thing about Mudiyattu is that it is performed for the purification and rejuvenation of community. It is the enactment of battle. That means it's a theatre. In theatre, some story you will have to portray. What is that story? The story of the battle. Between whom? Goddess Kali and demon Darika. This battle is portrayed in these ritual theatres of Mudiyattu, and this ritual is part of Bhagavati cult. And another beautiful thing about this, why it requires preservation, is that this is performed, Mudiyattu is performed today in just 4 districts of Kerala. Just 4 districts of Kerala after the summer harvest. So these 10 are very important intangible cultural heritages which need needs to be protected and preserved. And why we are talking about that? We are talking because on your page number 4 in your notes, India has launched an Intangible Cultural Heritage of India scheme. Ministry of Culture has launched the scheme, and the primary objective of the scheme is that more and more these intangible cultural heritages they find mention in the list of UNESCO. That is why we are talking about all these 10 important intangible cultural heritages. Fine. Do you want me to give you a break of 2 minutes? Raise your hands. Okay, come back in 2 minutes. We'll finish this lecture. Welcome back. If my voice is not clear, raise your hands. Okay, thank you. Let's get started with another important development in an area of science and technology, and that is reusable launch vehicle. What is a reusable launch vehicle? It's primarily a system which can be used or reused more than once to launch a payload. Normally, a system launches a payload and it cannot be used again and again. But reusable launch vehicle is that system which can be reused more than once to launch a payload. Those of you who think that India has a reusable launch vehicle? Please raise your hands. So majority of the people are raising their hands that India has a reusable launch vehicle, and that is why we are discussing it. India does not have a reusable launch vehicle yet. What it has? It has a prototype. Prototype, what we call technology demonstrator. TD. So we don't have a reusable launch vehicle yet, but what do we have? We have a prototype which is called technology demonstrator. This technology demonstrator will be used by ISRO. Why? So that we can test the various components. What are these components? These components which we can use for building a reusable launch vehicle. That means as of now we do not have a reusable launch vehicle. What we have is a prototype. What is that prototype called? Technology demonstrator. What this technology demonstrator will do, it will be used by ISRO to test these components, and then the results from these tests will be used to build better prototypes which can then be used for reusable launch vehicle. This particular test, or these tests which ISRO will be conducting, this will stretch till 2030, which is when ISRO expects to have a working vehicle, and which ISRO is saying will be 30 meters long. And this prototype, this reusable launch vehicle, will have an engine of India's own. Right? That means to build or construct these reusable launch vehicles, what ISRO needs to do, ISRO needs to conduct tests. Or experiments, and these experiments will then be used to build a reusable launch vehicle. And the first experiment for such a thing was conducted on May 23rd, and this experiment is what we call hypersonic experiment 1, or which you might have read in your newspapers, HEX 1. If it is a hypersonic thing, that means our reusable launch vehicle, that means the technology demonstrator of reusable launch vehicle is said to be hypersonic. That means the speed is close to Mach 5. That is what we call hypersonic. What is an alternative to this reusable launch vehicle? The alternative is what we call expendable launch system. What is this expendable launch system? As the name specifies, it is expendable. That means where each launch vehicle is launched once and then it is discarded. That means this vehicle can be used only once to launch a payload. It cannot be reused further to launch a payload. This is the alternative to reusable launch vehicle. Now let's talk about few facts, few very important facts. At present, and mark my words clearly, at present, there is not even a single completely reusable launch vehicle. No whatsoever. But what we have partially reusable systems, such as the one the NASA used once, that was called Space Shuttle. This Space Shuttle was a partially reusable system because the external tank used to be discarded and then it used to be reloaded again. But let's not get into that specifics right now. That's not required. What is important to point out is that something technology demonstrator was launched by ISRO, which is the first experiment so that we can create a reusable launch vehicle, which will take time till 2030. This is what ISRO is saying. Throughout the world, we never had a completely reusable launch vehicle, but what we had is a partially reusable system, which was used by ISRO, which was used by NASA. That is what we call Space Shuttle. Now, why are we looking at a reusable launch vehicle? What are the benefits? A reusable launch vehicle can bring down launch costs. That means the cost to launch a payload can be significantly reduced if we have a reusable launch system. And ISRO says if we have a reusable launch system, we can cut down the launch costs by up to 10x. But there is a flip side. What is that flip side? The cost of maintaining such a vehicle is much more than what polar satellite satellite launching vehicles or geostationary launch vehicles cost. Much more cost is required to maintain such a vehicle. These are few important facts which you need to understand from the prelims point of view. So from mains point of view, you need to understand why is it that the maintenance of such a vehicle is much more than a PSLV or GSLV mission, and how beneficial can ISRO's reusable launch vehicle experiment be for the cost cutting in our launch systems. But that is something for the mains examination, not from the prelims point of view. So I'm going to take up the last issue for this particular webinar. The rest are mentioned, I think, in details in your notes. So the last issue that we are talking about is dealing with intellectual property. What is this intellectual property? Why are we discussing it? We are discussing because National Intellectual Property Rights Policy has been thrown open, created by the government of India, and that is one of the most important news that we came across in the last month. The notes provide you all the details, what are the objectives for that. But I'll detail with something else, with something specifics regarding intellectual property. What is an intellectual property? Intellectual property refers to the creations of mind, such as inventions, literary and artistic works which are used in various important, for example, books, for example, movies. You have these are literary and artistic works. For example, designs and symbols, or names and images that we use in commerce. Basically, all these are creations of mind. Invention is a creation of mind. Literary work is a creation of mind. Designs and symbols, these are the creations of the minds. And these are collectively called as intellectual property. And this intellectual property is protected by law. How? Inventions are protected by patents. Literary and artistic works are protected by copyrights. Similarly, designs and symbols, names and images which we use in commerce are protected by trademarks. So these laws protect and promote intellectual property. And because of these patents, copyrights and trademarks, what exactly happens? It enables people to earn. What do they earn? Recognition. What do they earn? Financial benefit. Why? Because these are the creations of their minds. They should get recognition for that. They should get financial benefit from what they have created. And throughout the world, we have these laws which protect and prevent the infringement on these intellectual properties. So when we created National Intellectual Property Rights Policy, there are 7 objectives for that. And these 7 objectives are mentioned in your notes. But primary objective of this National Intellectual Property Rights Policy, if you ask me, there are two important objectives. One objective is, although let me reiterate, there are 7 objectives. So 7 objectives you will have to talk about. But primarily the objective are 2. One is to create awareness. What sort of awareness? About economic, social and cultural benefits of these intellectual property rights. And the slogan for that is Creative India, Innovative India. So what we are discussing intellectual property. What is an intellectual property? We know about that. How this intellectual property is protected by the law, we know about that through patents, through copyrights, through also trademarks. Why are they to be protected? Because for recognition and financial benefits for those who have these creatives, who have created these important things, because after all they are the creations of mind. When we created National Intellectual Property Rights Policy, there are 7 objectives for that. But I say there are 2 very important objectives within those 7 objectives. One is awareness should be created. What sort of awareness? That these intellectual property rights are very important for economically, very important socially, very important culturally. And this is to be disseminated to all these sections of the society. And for that awareness, we have a slogan called Creative India, Innovative India. So this is something that can be asked in your prelims examination. Second important objective is to stimulate generation of intellectual property rights. We know in India we have a huge knowledge resource. We have people who are working in various R&D factories or companies, research and development. Hundreds and thousands of scientists, engineers are working in different parts of the world. So there is no dearth of knowledge. There is no dearth of human resource. And the objective should be that we should facilitate these researchers so that they become inventors, so that they become innovators. Innovators of what? Innovators of those important items which form part of our national priority. So basically, what is the objective? There are people who are working as researchers in different parts of the world. They have knowledge. We have resource base. We have engineers. We have scientists. We have innovators. So the objective of this national policy on IPR is that we should facilitate these innovators. Why? So that they can innovate things. What sort of things? Those things which are required for national priority. What are these things? Basically pharmaceutical things, pharmaceutical projects, pharmaceutical objects. That means basically medicines they should be creating, which are a part of our national priority. They should be able to innovate in our atomic energy. They should be able to innovate in our space technology. They should be able to innovate so that Make in India becomes successful, so that Startup India becomes successful. That is what our intention is going to be, and we will facilitate. Because if we know the problem in India, we are filing more and more trademarks, but we are not filing more patents. So filing of patents is something that we should facilitate, and we should encourage our innovators. These two are very important objectives of this national policy. Apart from these, we have 5 other objectives. Let's briefly look at them one by one. Third objective is to have a strong and effective IPR laws. Strong and effective IPR laws so that these intellectual property rights are not infringed by outsiders, are not infringed by those individuals without giving benefit, recognition, financial benefit to whom? Those who are the innovators, those who are the creators. But still, this policy makes a very important statement. It says that even this strong and effective law, it must be able to strike a balance. Balance between whom and whom? Balance between interests of rights owners, and the interests of larger public interest. That means this is again a very important objective of our national policy. But this is something that very humbly I disagree with the government's policy. Why? Because this government policy is silent on two important issues. We don't know whether those issues have been incorporated in this policy or not. And this can be a potential question in your mains examination as well. What are these two issues? Let's briefly talk about them. One, next hour. Which was created by Bayer. Nexavar was a drug which was meant for liver and kidney cancer. This drug was manufactured by Bayer, and the cost of this drug was about 2.5 lakh per patient. Fine. But when this drug was available for patients for 2.5 lakh rupees, a similar company in India, Natco Pharma, which is based in Hyderabad, Natco company also manufactured the same drug, and the government gave them the permission, which is what we call compulsory license. That means Bayer company was manufacturing a drug. This drug is what we call Nexavar. Nexavar was used to treat liver and kidney cancer, but the cost of this drug was huge, 2.5 lakh per patient. So Natco Pharma asked Bayer, please can we also manufacture with your composition, but we will manufacture this drug in India so that the cost of this product can decrease. But since Bayer had a patent over Nexavar, they did not allow Natco Pharma to manufacture that drug. Ultimately, Natco Pharma went to Indian Patent Organization, and Indian Patent Organization gave a compulsory license to Natco Pharma. And Natco Pharma was then able to manufacture this drug at a very reduced cost, and ultimately it was beneficial for the people of this country. Why? That means in the larger public interest, what government did, what Indian Patent Organization did, they gave compulsory license to Natco Pharma, violating the patent which was given to Bayer. Even if the patent is with the Bayer, but Natco Pharma, we are giving you compulsory license for the larger public interest, you can also manufacture this drug. This clause, compulsory licenses, is absent in this national policy on IPR. Similarly, we had this Novartis case. Novartis was manufacturing a drug called Gleevec, and there they used to do what we call evergreening. That means they were changing the chemical composition of the drugs, but ultimately the efficiency of that drug was not changed. Efficacy remained the same, but they used to change the chemical composition so that they could apply for patent even after 20 years. This was rejected by Indian Patent Organization in the landmark case. Supreme Court in Novartis versus Union of India. They rejected the patent of Gleevec for a period more than 20 years. That means evergreening was prohibited in India. Compulsory license was introduced in India for the larger public interest. That means today, if we have this formula, if we have this policy that we should have effective laws for IPRs, but which must balance between the rights of the patent holders and the larger interest of the public, that is something which is missing in this law. So we don't know whether the new intellectual property rights policy will also curb evergreening, whether this new intellectual property policy will also give compulsory licenses in case of national interest, in case of public interest. This is something that this policy is silent about. That means, what are we discussing? Intellectual property. In intellectual property, what are we discussing? National Intellectual Property Rights Policy. This rights policy has 7 important objectives. What are these objectives? Number 1, to create public awareness. Number 2, to stimulate generation of IPRs. Number 3, to have a strong and effective IPR laws which must balance the rights of the interests of the rights owners as well as the larger public interest. So the case we saw in Novartis case, where the Supreme Court of India rejected the patent of Gleevec for a further period of 20 years, because what they were doing indulging in evergreening. They were changing the chemical composition of the drugs, but even then the efficacy of these drugs were not changed. Supreme Court rejected this, saying this patent cannot exceed beyond 20 years. Similarly, in Bayer's case, when they were manufacturing Nexava drug for liver and kidney cancer, compulsory license was given to Natco Pharma. Why? Because the cost of that product, which was manufactured by Bayer, was huge and which Indian population could not have afforded. So for larger public interest, compulsory license was given to Natco Pharma despite the violation of patent, but because it was in the larger public interest. Let's look at the objective number 4. The objective 4 is to modernize and strengthen service-oriented IPR administration. So basically, what is the objective of this point? The primary objective here is to make the offices which are these offices which deal with intellectual property rights. Make these offices effective and make these offices user friendly, so that it does not take a long time for someone to file for patent or trademark or for these copyrights. That is what the objective of this policy is all about. Another important objective is commercialization. That means here the stress is that if you are patenting a product, if you are given a copyright of a product or a trademark of a product, you should get the value for that. How? Through commercialization. So what is the stress here? The stress is that you must connect. Whom? You must connect investors and intellectual property creators, so that you can get the economic benefit from these intellectual property rights. This is another important objective of this national policy. Another important point is that how to strengthen the enforcement and adjudicatory mechanisms when there is IPR infringement, when your intellectual property rights are violated by other organizations. So if you have a patent for a product and I am using your patent without giving you economic benefit, without giving you recognition, you will file a case against me. So the policy objective of this policy is that it will be desirable if such cases of IPR infringement are brought to our notice. So we should have not regular courts, but we should have specialized commercial courts in this country. So these commercial courts, specialized commercial courts, should deal with the cases of IPR infringements, because you need experts to decide on these cases. These cases you cannot rely on the traditional judges of high courts and supreme courts. So if there are cases of IPR infringements, we need to solve those disputes. So it is better to have a specialized commercial courts to resolve those disputes. And as much as possible, we should have alternate dispute redressal mechanisms. That means alternate dispute recognition redressal mechanisms may be explored for this. That means you don't necessarily have to go to a court. We can use arbitration through this. We can use conciliation methods to resolve these disputes. And the last important point, last important objective is to strengthen and expand human resources, institutions. For what? For teaching, training, research, and skill building. Why? This is something which is similar to China. In China, the Chinese government took a very important step. They conducted workshops. They conducted training programs so that people are made aware about IPRs. And because of those workshops, because of those training workshops, because of those researches, what happened? There was a huge boom. the large number of people in China, they filed for patents, trademarks and copyrights. So ultimately what happened? The IPR strength of China became huge. But there is also a flip side. The problem here is we are blindly imitating China. In China, less than 1% of patents are high end. That means real effective IPRs are only 1%, even less than 1%. And majority of the patents which have been filed in China are at most mediocre. So this is something we should not blindly imitate China. Yes, we should encourage teaching. Yes, we should encourage training. Yes, we should encourage skill building and research, but we should be doing it so that we can ensure that high-end patents are filed in India and not the mushrooming of mediocre patents as is the case in China. 3-4 important issues regarding this. One is Department of Industrial Policy and Promotion, DIPP. It is the sole responsibility, it is the sole authority which is entrusted with intellectual property rights matters. This can be a potential statement in your prelims examination. DIPP, the sole body responsible with IPR matters. Similar to this, we have Marrakesh Treaty of 2013, which talks about access to published works for visually impaired. That means the published works that are there in the world. The authors and the creators of those works will have copyrights over them. But how can we make even these published works available to those individuals who cannot see, who are blind? That is something which is talked about this Marrakesh Treaty. And this is something that Arun Jaitley, Finance Minister, mentioned in the budget as well, where he recognized the interference by Rahul Gandhi. Rahul Gandhi had gone to Arun Jaitley and asked Arun Jaitley, please can we reduce the import duty on braille paper? Braille paper is responsible because of which these visually impaired people in India can also have access to those published works, because braille paper makes it easy and possible for visually impaired individuals to also have access to information. So import duty on these braille paper was reduced during the last budget. That makes it possible for visually impaired to get an access to published works. Who talks about that? Marrakesh Treaty of 2013. Similarly, we have Madrid Protocol, again of 2013. The objective of this Madrid Protocol is to ensure protection of trademarks, in multiple countries. How? So broadly, what are we talking about? We're talking about intellectual property rights. Why we are talking about it? Because a policy has been recently enacted by the government of India. What are the 7 objectives of that policy we have discussed? We have also discussed that the act or the policy is silent upon evergreening and compulsory licensing. To explain evergreening, we cited the example of Novartis Gleevec case. To explain what is compulsory licensing, I told you the example of Nexavar drug, which was manufactured by Bayer Corporation. Madrid Protocol specifically talks about protection of trademarks in multiple countries. How? That means if you have to file for trademark, you have to file only one application. That too with one office, that too in one language, that too with one set of fees, and that too in one country. So you are filing for trademark in India. For that, one application is to be submitted in only one office, that too in one language. Only one set of fees will be allowed, and that means only in this country you can file this trademark. But apart from these things, can you get your trademark registered internationally? For that, you have something what we call international registration. That means this international registration also can be granted to you, because once the trademark office in a country such as India, it grants you protection for trademarks, and this trademark is protected in this country, then you have to file an international registration. That means you want your trademark to be protected throughout the world also, because maybe your trademark, you have a trademark for your company in India, you want to create an office of that company in another country, so your trademark for that office should be protected even in that country also. So for that you will be provided international registration. And when this international registration is provided to you, your trademark will be protected in even that country also. So it will have universal application. The entire world application will be available for you. This is something that is talked about by Madrid Protocol. So this is something that we discussed in today's lecture about the current affairs issues from the months of April and May. This is all that I think you need to understand from the current affairs issues. There are some issues which are factual, such as Maritime India Summit, National Hydrology Product, similarly special heritage status to universities and colleges. These are something that are mentioned in your notes. Please go through them. In case of any doubts, please feel free to ask them in your mails. Now if you have some questions, please ask these questions so that I can answer. Okay, so the first question that is there, some questions have already been answered. Statutory means that it is created by an act of parliament or state legislature not mentioned in the constitution. Could you please repeat the priority programs? Now we have talked about them, and these are four priority programs of the Government of India. Pradhan Mantri Jan Dhan Yojana, Swachh Bharat Mission Gramin, Swachh Vidyalaya, and Soil Health Card Scheme. Which three things are related to Komagata Maru incident? Now, I didn't say there are three things related to Komagata Maru. I said there are three things which are related to the failure of Gadar uprising. That means primarily when Gadar party started, they made their point that we want to overthrow British Empire. And they came prepared and some people came to Punjab also through Sri Lanka, and ultimately they decided to wage a war against the British. But they failed in doing so. Why? There were three reasons responsible for that. The escape of Lala Hardayal, one. Second, Komagata Maru incident, because of which the Canadian government decided not to allow the passengers to deboard that Komagata Maru ship. And the third one was the outbreak of First World War. The alternatives to potassium iodate and bromate, I have talked about them. That means we are talking about amylases, we are talking about ammonium persulfate, we are talking about ammonium chloride. That is what we use as alternatives to potassium bromate and iodate, or that can be used. Who constructed Adai Dinka Jopra? It was constructed by Kutubuddin Aibak. Important species and their unique features and IUCN status. I have discussed this, I think, in almost all the classes, in all these roundups, beginning with August and September. So all those important species which are required from this examination, we have covered them. What is this 150 years that I was talking about? I was talking about that this breeding frog has been rediscovered after 150 years. That means this species is something that we have not discovered this year. But this tree hole breeding frog has been rediscovered because originally it was described way back 150 years back. And then nobody had ever seen it. And now we have rediscovered this. Wasteland frog currently is not endangered because it has been recently discovered, but it falls into the category. If we look at the category criteria for endangered species under IUCN's red list, any species which has a range of about 146 square kilometers, it falls under endangered category. Contingency fund is a statutory fund. Yes, it's not a constitutional fund. Article 267 of Indian Constitution merely talks about that a contingency fund should be created. That means an emergency fund should be created which can meet the needs of the government when there is an emergency. To create a contingency act, to create a contingency fund, Contingency Fund of India Act was enacted in 1951. That means Constitution merely talked about create an emergency fund. That is all that it was talking about. It was not talking about contingency fund of India. It was saying create a contingency fund, and we named that emergency fund as contingency fund of India. But since an act of parliament was created, act of parliament was enacted to create this contingency fund, that is why we say it is not a constitutional fund. Public account of India, consolidated fund of India is a constitutional fund, but not the contingency fund of India. No, Gadar movement did not begin because of Komagato Maru incident. In fact, the Gadar movement, if you look at the publications of the Gadar party, or if you look at the newspaper of Gadar, which was called Gadar Di Gunj, it primarily made one startling claim: Angrezi Raj ka chitta, Gora chitta. That means it was explaining the flaws of the British colonialism in India. So even before Komagato Maru incident, they had made it absolutely clear that we will overthrow British Empire through force. Komagato Maru incident only played a spoil sport in that adventure of Gadar party. It was not because of Komagato Maru incident. How to compensate for the losses of tobacco farmers? Then this is the policy which is created by Agriculture Ministry also. That means in areas where we grow tobaccos or BDs, how should farmers be compensated for their loss then? Then we have to subscribe to them alternative crops such as onions. So onions can be grown on these crops and not tobacco or BDs. So they can be compensated for that. PDF documents are not opening, they will open definitely. You try it again. So everybody else is able to open them. Why are domestic violence cases under civil law? Because primarily it deals with individuals, two individuals. The state has nothing to do with that. So it cannot be a criminal law. A criminal wrong is a wrong against the state. If you are committing a wrong against an individual, it has to be a civil law. But we say there are some crimes which are called impact crimes. For example, racism. You are not committing racist activities against an individual, but against the entire community as such. So it has an impact on the entire community of blacks or whatever you call them. So that is why these are criminal wrongs. Yes, we talked about that United States had a space shuttle, but it is not a completely reusable launch vehicle. It's a partially reusable launch vehicle. Do I need to know what material used in RLV or technology to be used in it? Not required. But in any case, if you want to go through that, there is a beautiful article in thewire.in, wire.in. Beautiful information is provided in that. You can go through that for additional information. From examination point of view, not required. So there are some people who are asking about the Special 301 report. It's a report under US Trade Act of 1974. There is an office called US Trade Representative. It has to prepare a list of countries whose IPR regime or IPR laws have a negative impact on American products. That is why US governments impose sanctions on those countries. But there are some countries which are called priority foreign country. That means against whom US government will impose sanctions. But there are some countries which are called priority watch list. And in this list you have India, you have China, you have Russia. But priority watch list countries, sanctions are not imposed by the US government. So what they do, they use a carrot and stick policy. That means they take Indians to United States, give them a good sound hotel to stay in, give them the opportunity to interact with other government officials, give them an opportunity to tell them how the IPR laws are working in United States so that they can persuade their governments back in India how you can make your IPR laws relevant and compatible with IPR laws in America. So that is something which has to do with United States. Can you explain the term efficacy? That means primarily if there is a drug which you are administered, what is going to be the benefit of that? If the drug can cure your disease in 10 days before, but then you are changing the chemical composition of this drug to such a degree that your deficiency or your disease can be cured in less than 10 days of time. That means basically the efficacy of this drug has improved. If the efficacy of that drug is improving because of new chemical composition which you have added, then you can even apply for another patent. And this another patent can extend beyond a period of 20 years also. But since in Gleevec case, what they tried to do, Novartis tried to change the chemical composition. But when you change the chemical composition, but the efficacy of this drug does not improve substantially, then you can't ask for a patent extension. That means you have not done anything to increase the efficacy of this drug. So we can't provide you with the patent extension. That is what we call evergreening. So what Gleevec used to do, what Novartis used to do, in Gleevec they used to change chemical composition and they used to tell Indian Patent Organization, see, now the composition has changed, so we require patent for this new composition also. But Indian Patent Organization said this can't happen like this. Why? Because you have changed chemical composition, yes, but since efficacy has not increased, has not improved, so by evergreening your product so that forever and ever we will provide you with the patent, that is not something that we will do. New IPR policy does not contain anything about evergreening or compulsory license. Please confirm. So what is it that we are talking about? We are talking about that there is a very important objective of this policy, IPR policy, which government has released. What is that policy? That we will strike a balance. Balance between whom and whom? Balance between the owners of these rights and the larger public interest. But even this clause is not specifically talking about whether evergreening will be prohibited or whether compulsory license will become an integral part of our policy or not. Because if the price of a product, despite being patented, is huge, which cannot be afforded by Indian public, so Indian Patent Organization gives compulsory license to an Indian company to manufacture that drug so that this drug is available at a cheaper cost to the people of this country. That means despite patent, we are violating the patent norms, but that is something which is allowed under India's laws. But because of this new policy, we are still not sure whether evergreening will continue to be prohibited in India and whether compulsory licensing will become a norm in India. That is something we have no clarity about. DIPP, Department of Industrial Policy and Promotion, is the single authority which is responsible for IPRs, intellectual property rights. Madrid Protocol is for trademarks. NSG, NPT we discussed in the first webinar, but NSG is something which is, the story is developing. So we saw on Thursday what happened. We saw on Thursday when the matter was taken up at Seoul, ultimately Russia and also we saw Turkey and we saw Brazil along with China. They objected to the India's entry into NSG. So this story, since it is developing, we will discuss this in the next webinar issue. In Enrica Lexi case, the term security guards is used and not marines. Why? Because these were not originally marines, but they were security guards who were taking care of this oil tanker called Enrica Lexi. That means they were primarily there to protect this Enrica Lexi. From whom? From the pirates. Because if we look at Indian Ocean, it is a very important and notorious place for pirates also. So that is why the term is used, security guards and not marines. The notes have been provided to you. Please check your mail. As I said, important species which are required for this examination, considering their IUCN status, we have covered almost all of them till May. Whatever is left will be covered in the next current affairs roundup session, so you don't have to worry about that. Cheraman Perumal King, he was the king of Chera Empire. He is believed to have traveled to Arabia, where he met the Prophet of Islam and converted to Islam. And after that, there came one individual, Mr. Dinar, and who established or created or set up or built the Cheraman Mosque in Thisrur.